Okay. Hold on, Shannon. I think, can someone reach out to Mr. for your patience? Shannon, if you want to go ahead and get started with the housekeeping, I would appreciate that.
Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Grant Eligibility and Support Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference. Per Bagley-Keene requirements, all cameras must be kept on for the duration of the meeting. If you are unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of your surroundings behind you. All committee meetings will be recorded and posted to the State Bar website. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen, then select Enable Auto Transcription. Thank you.
Thank you for that, Shannon. Can we do roll call, Crystal?
Yes, I'll go ahead and get started with that. Gonzalez.
Here.
King.
Here.
Klein. Milrod.
Here.
Pryor.
Here.
Stalker.
Here.
Galkin.
Here, yes.
Thank you. Okay, great. I'll go to our advisor, Justice Rodriguez, and then Judge Juan Gutierrez. I believe are both absent today. Our liaisons, Selena Copeland.
Present.
Thank you. Lauren Klein, Melanie Snyder, Yoon Kim. I'll also make note of State Bar staff present. Jason confirming that we have quorum with 6 members present.
Thank you, Crystal. So given the number of participants that are present, at least for now, I'm going to propose that as we move to public comment, that public comment be limited to 2 minutes to ensure that anyone who is providing public comment has adequate time to provide one. A note regarding public comments, please make sure that your public comments are related to the agenda and the matters to be addressed by this committee, or matters more broadly related to the subject matter jurisdiction of this committee. And with that, I will turn it over to see if we have anyone who would like to make public comment.
I don't see any. Oh, we actually do have one. Oh, a few people now. Okay, they're coming in. We have two. Crystal, do you want to call them or in order? I see Joseph first.
Oh, I'm sorry. Second.
So Shannon, we've promoted Joseph Carrico, unmuted him or them.
Yes, he should be able to speak now.
Hi, can you hear me?
Can you hear you? Yes.
Okay, I just wanted you to know that we are here. My colleague Marilyn Munra is also on the call too, and I believe I can't see her, but I believe she's also joining from another location. And we are grateful for this opportunity to rejoin California Bar Funding. We fell out last year because we had challenges with our audit and our auditor. And we have a new financial review that I understand is coming in tomorrow. And we believe that we will be able to re-enter this funding source and turn things around. And we're appreciative. And if you have any questions, we will be on the call until after our agenda item, after we're addressed in 4.1. And that's, I guess, all I need to say now that we're here if you have any questions. And if you have any questions for me now, I can definitely see if I can respond.
I'm sorry, which program are you with?
You've been Sutter Legal Center for Seniors.
Thank you.
Thank you, sir.
Thank you. I think we can move on to the next person. Thank you, Joseph.
Oh, good afternoon, Commissioners. I'm calling in regards to Agenda Item 4.1. My name is Nisha Vyas. I am with Public Counsel, and I'm commenting today on behalf of Public Counsel that we agree with the staff recommendation, finding that Public Counsel is eligible for the pro bono allocation under the Method 2 analysis. And we want to express our thanks to the Grant Eligibility and Support Committee, the staff, and the full commission for your support.
Thank you.
Hi, hello. This is Erika Lomeli Corcoran with the UFW Foundation. The UFW Foundation is a nonprofit 501c3. We have offices in Salinas, Fresno, Bakersfield, and Oxnard, and our work is focused on legal services, immigration, workers' rights, policy change, and just over the years, our largest department is our legal service department. This was the first time that we have applied with the California State Bar. Have learned a lot and have definitely made just great relationships. So I really appreciate just the support that all of you have given to farm workers in rural California. And just wanted to say that on behalf of the UFW Foundation, we appreciate the opportunity and the consideration that you're all taking today. Thank you.
Thank you.
Hi, everyone. My name is Vidya Raghunathan, and I am the Director of Pro Bono at Inner City Law Center, a nonprofit organization focused on housing and homelessness prevention work in Los Angeles County. And I just wanted to speak very briefly on Agenda Item 4.1 and just note that we support the staff's recommendation on the issue of pro bono allocation and really appreciate working with the State Bar staff on this issue as it's a particularly important one right at this moment and moving forward.
Thank you.
Good afternoon. This is Carmen Chavez. I'm the Executive Director of Casa Cornelia Law Center here in San Diego. I don't know, I'm unable to turn on my camera. I do apologize. It doesn't have where I can change that. But I wanted to say thank you so much for your consideration. We are also hoping that the commission rules in favor in the determination on the pro bono allocation. And we are very deeply grateful to the State Bar staff for their support and working with us. And we hope to have your support so that we can continue our work. Casa Cornelia Law Center provides free legal services to the immigrant community here in San Diego, right along the border. And ever more so has become very critical in our work to have the support of the private bar. Thank you so much for your consideration.
Thank you.
Hi, good afternoon. My name is Sarah Levine, and I'm the Pro Bono Director at Betzetic Legal Services. I'd like to thank the committee for its recommended approval of the pro bono allocation this year, and to express our great appreciation for working with the State Bar on this issue. Here at Betzetic, pro bono is a vital, meaningful, and really central part of all of the work that we do. Every day, our agency is on the front line serving clients with pressing legal needs, and we have a full-time pro bono team dedicated to overseeing volunteer engagement and pro bono programming across all of our practice areas, whether that's through a packed calendar of pro bono clinics or a high volume of case placements under the close guidance of a Betzetic attorney. Every day, we're really dedicated to ensuring that every volunteer looking for an opportunity is matched with a tangible, meaningful way to give back. So as I hope has been demonstrated, pro bono is a most significant part of how we deliver our services. And the pro bono allocation makes all this a reality. So we really thank you all again for your support.
Hi, this is Julia Hannigan. I'm the Policy Director at Dependency Legal Services. We're a first-time applicant, so I want to thank the staff for their tremendous patience with me, and and I also wanted to thank the State Bar for their recommendation, and we're in support. Dependency Legal Services represents parents and children in child welfare proceedings, and we're hoping with this grant to use this to intervene with families prior to the filing of petitions, so we can help more of our clients stay together and avoid child welfare intervention. So thank you so much for your time and for this opportunity.
Thank you. From what I'm seeing, I think that is the last of public comment. So with public comment wrapping up, I will move us on very quickly through the chair's report, because I think we had, like last time, no major updates from the chair in between meetings, no major updates other than what we have for business items. And so we'll talk about them as business items anyhow. And I will move us to Dwan and the director's report.
I just have two quick updates, but first I just want to thank everybody for your participation in the Eligibility Review Conference. For this particular committee, you all know that the work, unfortunately, spans the summer, so we really appreciate you dedicating your time, reading the voluminous amount of background materials for each of those ERCs and interfacing with the staff. And you'll hear a little bit more about where we are on the IOLTA process when Erica presents on 4.1, but we really are at the tail end now of our review. The staff have completed the review of every single applications, but for the 3 that are going to be discussed a little bit more that had the eligibility review conferences, we've taken care of kind of all pending issues. That set of recommendation will go to the August 8th commission meeting. And shortly after that, what happens is once we have a list in hand that's approved by the commission for eligibility, the staff spend the next 2 weeks running the formula. So it's a statutory formula to determine the grant award amount for each organization. And just so you know, in our office right now, because it's such a complicated formula, there are already a lot of preemptive steps that we do in order to get that ready. We run a test case. Crystal manages checking it, and we have several staff checking everything to make sure everything is kind of correct and teed up to go, so that we're ready to kind of release the allocation towards the end of August there. Again, just expressing my thank you. The other update that I have for you is I was temporarily filling in as a committee coordinator for this particular committee for the last 2 meetings, as you know. And so we're doing a little bit of a shuffle in our office. So I will still be around, and obviously I'm still the lead contact for the Legal Service Trust Fund Commission. But starting the next meeting, you will have a new staff coordinator, and that's going to be Chris McConkey, who I think a lot of you have worked with in kind of different capacities and other grants. He's going to move over from the Program Development Committee and staff this committee. So you'll be seeing him, and then our new director of grants, who's not so new anymore, Joyce Song. Joyce and Chris will be running this the committee, so you'll see more of them. A little bit less of me, but I will be in and out of the meetings. So it's been really a pleasure working with you, and Jason, having a chance to work with you the last few meetings so closely. So with that, I'll hand it back over to you.
Well, as chair, on behalf of my fellow committee members, thank you, Dwan, for subbing in and covering us in the meantime. We really appreciate your help. Waiting for a car to drive.
Dwan, can I ask a question to make sure I'm clear about the funding allocation?
Yes.
If a new program is funded in an area that's already served by an existing recipient, then it's a zero-sum game. Is that correct?
Yeah.
It'll go one grant will go down and the other will go up. Is that correct?
Yeah, it's a little bit of a complicated formula, but I'll generally kind of go over the broad strokes. So if you recall at the last, I want to say either the last meeting or the meeting before that, every year one of the main functions of the commission is to determine the allocation amount for the next year for our interest, our IOLTA interest on lawyer trust account grants. So that's a fixed amount, and it depends on kind of the revenue we have. We are set to make a recommendation to the board of roughly $217 million based on the amount of money that we have pulled in this year and we project for the end of the year. The other fixed amount is because we run both our IOLTA grants and our Equal Access Fund grants this together, because they're pretty much the requirements are nearly identical. That Equal Access Funding grant, it's an allocation on the state budget that's approved every year, and we know we pretty much we can rely on it, even though it needs to get approved. It's a fixed amount. It's about $35 million, and Crystal can correct me if I'm wrong. Of that, I think $31 million is going out through formula, and the other 10% is going out through partnership grants. So again, those are both fixed amount. And then how the formula works is every county gets an allocation based on the number of people in that county that are below 125% of the federal poverty threshold. And then within that county, how that money gets divided this is why this application is so tedious. We look at the previous years of expenditures for each program, and then they get a pro rata share based on that county. So I'll give you a really easy example. Say if a particular county has $1 million allocated based on the number of poor people in that county, and there are 3 programs in that county, and they each have identical qualified expenditures, then they each get 1/3 of that. So if there's a new program that comes in, it will impact to the allocation because there's only so much money that's allocated for that particular county. But then it's complicated because it really depends on how much you spend. So obviously, if it's a larger program that comes in, it's going to have a bigger impact. You'll see with a couple of the programs that are new this year, they are applying for an allocation in several counties. So then it makes it very difficult to predict. I mean, we can kind of eyeball a little bit, but there's a lot of factors that come into play. So it's not only the amount of money that you spend in that county for a particular program, but it's really your neighbors. And so that's why it's such a complicated formula. The number of people in a particular county that are below 125, there aren't that major swings. I mean, there are some movement. We base it on census data, but that's not where like what's driving the grant awards. It's really been the main drivers are the new organizations that have come through in funding the last few years. And you will see this when we go to kind of look at the we used to hover between I would want to say on 99 and 102 organizations that qualify for funding every year. That number had been pretty much static for 20-30 years. The last few years, because of the increase in need in California and the scarcity in kind of resources, there has been we're getting more funding requests. And so if we end up approving all the organizations that are applying for funding this year, we're going to be at 120. So that's going to be a 20% increase in the amount of grantees that are eligible for funding. So because of that, again, the pot is so large, it's programs are going to get less, but depending on what county you sit in, you'll feel the impact of that more or less. So I hope that answers your question.
Yes, thank
Just
you.
to emphasize one thing from Dwan's comments, because she mentioned it once, but highlighting it or underlining it, I think it's as we can see in some of these applications, the ratio of qualifying and unqualifying isn't uniform across organizations for activities. And so if an organization has one distribution and that distribution of their activities changes significantly, that can also change how this works formulaically, right? So if they went from kind of like 55% qualifying and 45 non, and then went to 80-20, right? That could have a significant swing depending on how large the program is and the scope of their expenditures. So that's another thing to keep an eye on as we look at, especially some of the programs who are qualifying based on their narrative explanation of how they're doing things and whatever. Like, so I think it's looking at the details also has an implication. So I think Dwan's right in saying like it gets complicated as you get into the nitty-gritty details. It's not just like number of organizations divide by from a total county event.
But Jason, that's a retrospective look after, at the end of the budget year, you're looking back to see what percentage is on qualifying. Is that right?
Yeah, we look at the previous fiscal year, and the one wrinkle to that is like organizations have different fiscal years. So that's something we can't quite smooth out. We hope that because most of our grantees are like longstanding, it'll kind of just smooth itself out from year to year. But it's they're not all on a calendar year. Some of them have fiscal year ending in June, and the other half have in calendar year. But sorry to cut you off, Selena.
Oh, no, I was going to add another complicating factor. Since you're a newer member of the commission, I think a really tricky thing too is that there may be dedicated funding, including state funding for a particular purpose like immigration or housing. And so when some organizations in a region get that funding, but others don't, then it means that those organizations that had politically important reasons to fund their work, they're getting a larger share in future years. So I've definitely heard from a lot of organizations that because their organization didn't get HP funding or their organization didn't get immigration funding, that they're concerned about their IOLTA award shrinking. And so it does create this like, I don't know what the best metaphor is, but it does create this like if you eat more pie and found more pie, you get more and more and more and more pie. And if there wasn't enough pie served to you for whatever reason, then your IOLTA pie shrinks too. So it's definitely something that we've been aware of. And I know that the Shriver grant was written so it wouldn't count towards QEs, but not every funding source is written that way. And so when we see organizations come in who have a significant outside source of state funding, that gives them a larger share of IOLTA funding too.
But there's two things I do want to note. We were talking about it in terms of the allocation for our qualified legal services providers. So there are direct services for our 22, I believe it's 22 support centers. The formula is a little differently in that it's just 15% of the allocation, and then they do share that piece equally amongst themselves. But I would say the entry point for a support center, because there's a little bit different requirement, is a harder entry. So we've only seen, I think, in the last 5 years, one new support center that has entered, whereas the vast majority of the new ones have been QSPs. So something else to keep in mind. But Jason, turn it back to you.
Seeing nods, and I assume it's clear, or at least clear as mud. It took me at least a couple of years to start wrapping my head around all the different formulas. So I appreciate it for new folks. Moving on, I think hopefully everyone has had a chance to read the minutes from our last meeting, June 24th. I would invite a motion to approve those minutes.
So moved.
I'll second.
Milrod and King. Crystal, do you mind taking roll to approve?
Yes. Gonzalez,
Yes.
King,
Yes.
Klein, Milrod,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Falcon.
Yes.
That's 6 yeses, 0 nos. Motion passes.
All right. Well, with that, I think we will move on to the thick of it and get into business item 4.1, which I see Erica, I believe you are going to present for us.
Yeah, thank you. Let me share my screen. Okay. Well, good afternoon, everybody. For those of you who I might not know, I'm Erica Carroll. I'm a lead program analyst with the Office of Access and Inclusion. And I'm going to be talking to you today about the approval of recommendations regarding 2026 IOLTA and EAF applications. To give you just a little bit of background before we get into the issues that are the substantive issues for the committee's consideration, I think Dawn kind of provided a good overview. This year we had 120 applications, 6 were from new qualified legal services projects. 4 of those 6 are organizations that primarily focus on immigration legal services. We have 1 focused on juvenile dependency and 1 that does more systemic advocacy with a combination of impact litigation, policy advocacy, education, and direct legal services. So some good variety there. Staff has spent the better part of the last 2 months reviewing these applications, requesting revisions, and providing a significant amount of technical assistance to our applicants to reach this point to make our ultimate eligibility recommendations. So thank you to them for the work that they've put in to present this to the committee today. Today's discussion will focus on issues that the committee either needs to determine or make recommendations to the full commission on. And so that will be primary purpose and function requirements, eligibility review conferences that were held with applicants, the pro bono allocation, as well as our ultimate eligibility recommendations. So we'll start with primary purpose. So all applicants for IOLTA and EAF funds, under the statute, they need to have a primary purpose and function. In the case of qualified legal services projects, it's a primary purpose and function of providing civil legal services without charge to indigent persons in California. For support centers, it's a primary purpose and function of legal training, technical assistance, and advocacy support. Without charge for the provision of civil legal services. And so an organization, in order to demonstrate that, in order to establish its primary purpose, we look at their qualified expenditures in the prior year. So we have their total corporate expenditures in the prior fiscal year, and then the amount that they spent in the case of a QLSP on free civil legal services to indigent persons. Those would be considered qualifying expenditures. And so we look at how much of their expenditures were made up of those services. In order to be presumed eligible, if you have 75% or higher in terms of qualified expenditures, you would be presumed eligible. Organizations that fall below 75% have an opportunity to provide a narrative explanation as to how they meet the primary purpose requirement, and that's what the committee will be looking at. So they, as part of their application, provide that narrative, and it's elevated to you for review. Historically, organizations between 50 and 75% have the opportunity to provide that narrative and have potentially been found as meeting primary purpose. Organizations below 50% have not been found eligible. So, and any applicants that have other outstanding eligibility questions, those would typically go to a review conference. But the ones that we're going to talk about right now, the only really major question of their application was this primary purpose piece. So in your memo, we talked about Family Violence Law Center and Pangea Legal Services. Family Violence Law Center is a qualified legal services project. They're an existing grantee. They operate in Alameda County. Their primary purpose percentage came in at 57.7%. They provide holistic services in the area of domestic violence. And so they provide legal services, but they also have crisis intervention and youth leadership and violence prevention programs that they provide to their client base. And so they explained in their narrative about how they track legal services and policy advocacy, how they distinguish between legal and non-legal work for their family violence intervention unit. For example, that unit does their intake for legal services, but they also have a mental health therapist who provides support that is not part of the legal team. And so they had detailed notes about how they kind of come up with this methodology for calculating their expenditures that are non-qualifying and deducting. But they are a grantee that has received funding for many years. They have had this service model for that amount of time as well. And so they have remained consistent in terms of their service delivery and justifying why this holistic service model works for their client population. And so, staff is confident in the way that they calculated their primary purpose and that they've provided sufficient justification and would recommend approval for Family Violence Law Center. The second organization that fell below 75% was Pangea Legal Services. They are a first-time qualified legal services project applicant. Their main focus area is immigration legal services. They explained in their narrative that they have a horizontal structure for their staff, and so that means that all staff to some extent are involved in things like administrative work. And so they it's essentially spread across all staff. They intend, with additional funding, to hire additional administrative staff, and then presumably will, be using their funding from these grants for legal services, which would likely bring their percentage up. They fell just below 75% at 74.4%. And so their explanation seemed reasonable to staff as well. And they are recommended for approval of meeting the primary purpose requirement. That's it for primary purpose. So I would next turn to eligibility review conferences, but I wanted to pause if there were any questions on this piece. Patience.
I wonder if we could take these, decide on these, or do we have to go all the way through? It would be helpful. I don't see this as a single vote, potentially. So
yeah,
I would like to move that we accept the recommendation of staff with respect to these two programs and approve them as to primary purpose. Recommend that the commission as a whole approve them as to primary purpose. I'm not sure whether we can approve them or not. It's the commission has to do that.
I would second that. I think that's a good idea to take them separately.
So
Are you comfortable with that? Okay.
I'm okay with splitting it, and that way we can kind of handle them in smaller chunks. So I'm fine with moving forward with the proposed motion in second, so that we can do it. We don't have a documented motion, so I feel like I'm putting Eric on the spot. But I think principally we're approving staff recommendation here. I think that's what the motion is. So.
Erica, go ahead. I think the motions are separated out in the memo, so I was assuming.
Yeah, I can try to read it if that would be helpful. Let me just pull that up. Sorry.
So I'm seeing at page 11 of the PowerPoint, there's a resolution here.
Yes. So
it's in two parts. One addresses the primary purpose, and the other addresses to the Dependency Legal Services and United Farm Workers Foundation, which is I would take them separately.
Sure. So I'll read in the resolution, the piece that addresses primary purpose, so that everybody feels comfortable with it. That resolution was, should the GES committee concur, it's resolved that the GES committee recommends the Legal Services Trust Fund Commission find that the following 2026 IOLTA EIF applicants have met the primary purpose requirement. That's Family Violence Law Center and Pangea Legal Services.
So that's the motion. Angie, do you second?
Yes.
Wonderful. Crystal, do you want to take a roll on that?
Yes. Gonzalez?
Yes, but abstain as to the Family Violence Law Center.
Okay, thank you. King?
Yes.
Klein? Milrod?
Yes.
Pryor?
Yes.
Stalker?
Yes.
Dalkin?
Yes.
Okay, that's 6 yeses, 0 no's, 1 abstention. Motion passes.
Great. Thank you. So now we'll move on to eligibility review conferences. Again, just to give a little bit of background, an eligibility review conference is typically held during application review, though we have held them at other times during the year when necessary, but they are intended to address questions or concerns that require additional time or analysis or commissioner input. So novel questions related to applications or questions that require commission discretion, for example. So it provides a direct line from the applicant to the commission that's facilitated by staff. And so it's not uncommon for our newer applicants to require an eligibility review conference given their lack of familiarity with the grants and the detail that's required in completing an application. Recommendations from the Eligibility Review Conference are recommendations that come from the commissioners who participate to the larger committee. And 2 eligibility review conferences were held this year for new applicants, and then 1 was held for a formerly funded applicant, but not currently funded. And so this first one is Dependency Legal Services. So they are a qualified legal services applicant, a first-time applicant, applying in 5 out of the 6 counties where they operate, and they provide court-appointed representation to adults and minors in juvenile dependency cases. The question that arose in this application review was whether the organization had sufficiently demonstrated community support for their program. Typically, the way organizations do this is by demonstrating a minimum of $20,000 in outside local funding for their program. The eligibility guidelines allow an organization to provide other, demonstration of community support, but that's not commonly used. It's usually the $20,000 requirement is kind of the standard for most organizations. And so since this hadn't been applied recently using other demonstrations of community support, that's why this organization was referred for an eligibility review conference. And so during the eligibility review conference, Dependency Legal Services described more fully their engagement with courts as well as their non-cash community support. So the organization receives a lot of state and federal funding. In particular, they have contracts with the Judicial Council, but through the ERC, the organization was able to more fully describe their relationships with the local courts where they are actually operating, and the involvement of the courts or the judicial officers there in selecting contracts or giving feedback on their services. And then they also talked more about their partnerships with local schools, legal aid organizations for things like education law and immigration law, as well as partnering with nonprofits on things like parent mentor programs. And so the team was satisfied that there was a lot of local involvement and support for the organization's operations, and as a result was recommending that they had demonstrated the necessary community support to be found eligible for funding. And so that is the ultimate recommendation from that eligibility review conference, is that Dependency Legal Services be found eligible because they've demonstrated that community support. Yes, Bob. Sorry, Bob, go ahead.
You're on mute, Bob.
Sorry. Do we fund other organizations that do dependencies?
Yes, we do. Sorry, I'm blanking on the name right now, but we do have other.
Yeah,
yes.
They're both in the Bay Area. One of them is the Legal Advocates for Children and Youth program at the Legal Aid Foundation of Silicon Valley, and the other is Dependency Advocacy Center, both in the peninsula of the Bay Area.
Any other questions about Dependency Legal Services? Oh, sorry, go ahead, Bob.
Yeah, I have another question, and that is, could you explain the difference between what they're proposing to do with this grant and what they already do with the contracts with the Judicial Council and others?
Yeah, I mean, I think ultimately that would be more fleshed out once they submit a budget if they're found eligible. But my understanding from what Julia mentioned during public comment is that they are hoping to use IOLTA and EAF funding to assist individuals prior to their actual involvement in the dependency system. So prior to the opening of a case, a child welfare case, that they're trying to intervene with legal services that are more preventive or protective rather than the work that they're currently doing, or continuing the work that they're currently doing, providing services to those who are already involved in an open dependency case.
and I was part of that ERC, and we did stress for them the importance of, if they were found eligible, that when we get to the budgeting phase of it, if they already received funding, whether it's from the courts or another entity or another source of funding, what they need to budget for us needs to be different, so that it's not like double dipping. And they did talk about their pre-petition work pretty extensively, that's what they would be doing, as the person from the organization mentioned in the public comments.
Any other questions about dependency legal services? Okay. Great. Then our next eligibility review conference was with United Farm Workers Foundation. They are also a first-time qualified legal services project applicant, and they are applying in Kern, Fresno, Monterey, and Ventura counties. They provide both legal and non-legal services to farm and immigrant workers in the areas of immigration, workers' rights and climate justice. They engage in policy change and also power building and narrative change. So the questions that were brought to the fore regarding United Farm Workers Foundation were whether their qualified expenditures, one, would meet the primary purpose requirement because they fell below that 75% threshold, whether they had accurately deducted for all their non-qualifying work, some distinction between their public-facing materials and some of what they had submitted as part of their application, and whether there was alignment between their activities. And then whether the organization had an appropriate methodology for calculating qualified expenditures and applied it correctly. So there were a number of questions, but like ultimately what we were looking at was whether they had correctly identified work that would not be considered sublegal services to indigent persons, and then had applied a correct calculation to that work to deduct it from their qualified expenditures total. And so this application required a significant amount of technical assistance from State Bar staff that led to some variation in their qualified expenditure percentage based on several rounds of edits. And so when the application first came in, the qualified expenditure percentage was quite low for this organization. After feedback and technical assistance from staff, I believe it had gone up to about 71%. Again, after further discussion and kind of definition around these things, it's gone down. And so ultimately, the final submission that we received brought qualified expenditures to 59.97%. Going into the eligibility review conference, staff still had a recommendation to the team that requesting additional information would be appropriate, and additional clarification from the applicant because of the significant amount of discussion and revision that had taken place with the application prior to the eligibility review conference. And so during the eligibility review conference, there was a lot of discussion about the methodology for the organization's legal and non-legal services, how they calculated things like their out-of-state work, and just their total deductions. And so my understanding is that they explained, for example, how they deducted all out-of-state work because QLSPs should only be counting qualified expenditures in California. That they explained legal and non-legal staff track their work by their time, and so they were able to apply a pro rata share to any activities or staffing classifications that would be considered non-qualifying. That they have other grants that have legal components that require this type of tracking, and they deducted their community organizing for any community organizing that didn't have a legal component. They also track their legal and non-legal work on social media. They have different tags for those types of posts to be able to tease out which is qualifying and what's not. But some of the concerns were that, almost half of the staff were non-legal in nature. They have 91 staff, but 41 of them are considered other staff rather than, say, attorneys, paralegals, or clerical. Their public-facing materials, they explained, are tailored to a specific audience and to their client base, and so they want to be sensitive to the needs of their client base, their privacy concerns, and develop trust and recognition in the community. And so some of the concerns of their public-facing materials might not always cover everything that the organization is doing, but they did explain why that was the case and sort of how they conceptualize what they put in their public-facing materials versus a grant application. If they were found eligible, as mentioned, their qualified expenditure percentage is at close to 60%, so they would need to be found as having established primary purpose. And so, after the discussion, the commissioners on the team recommended finding United Farm Workers Foundation as having met primary purpose and recommended them as eligible. I will say that anecdotally, after posting materials for this meeting, staff has heard that there have been some concerns in the community about the accuracy of this organization's qualified expenditures, or that enough was done to really parse out qualifying versus non-qualifying work. And so, as I mentioned, staff had recommended going into the ERC that we obtain more information from this applicant. But the team and ultimately the commissioners felt that it was sufficient what had been presented during the course of the discussion to establish and answer the questions that had been raised prior to that. And so, I would invite, I believe, Patience and Bob were the commissioners on that ERC. If you have any additional recollections or thoughts on what was discussed that you want to share, please feel free to chime in. Otherwise, I would invite additional discussion or questions about this one as well.
One of the things that can't be quantified at this point, but because they came at just about 60%, the feeling in the team was that it's close enough, given the fact that there's quite a bit of work that the organization does that doesn't fall into some specific category of deliverable for existing grants. That is legal work. And they are committed to doing a better job documenting pro bono work, pro bono contributions. And so between that and the fact that they have applied for additional grants, they've added an additional lawyer, and they've applied for additional grants that are focused on and centered on and provided for the purpose of legal work. And so given all of that, and given the critical nature of the work that they do in the communities where they do it, some of which is quite remote and not otherwise served, we felt that it was taking the whole picture all together, that they meet the standard, and there didn't really seem to be any reason to send them back to create more, deliver more data. That we were satisfied that this is a organization that does do and will continue to do important legal work, principally legal work in areas where it functions. So that was our rationale. Jason?
Yeah, this is more of a question for Erica from the staff perspective, and I just want to make sure that as we're considering this, somewhat for my own edification, but perhaps for other members as well, I was reading the memo, and kind of, Erica, you referenced this, that the number for QE kind of bounced around quite a bit. And it gives me some pause, recognizing technical assistance in this process, like other things that we've talked about today, is not the simplest. It is somewhat complicated and unique to how we define certain things that, relative to our grants. I'm curious about what, if any, validation goes into the numbers that are provided that got us to, just shy of 60%. Or is it more of that number seems really low, and then that number seems kind of high, let's kind of talk through this, and then we're not validating their work so much as just, are we taking them at their word, so to speak, like letting them do the homework and then assuming that it's done in alignment with what the categories of appropriate expenditures are relative to our rules, or is there kind of more of a validation step that is happening as part of this from staff?
I can jump in on that because I was involved in reviewing this up to the point of participating in the ERC, and the staff members that participate in that are on call to have any specific answers. But we do rely a lot on like self-reporting, and this is why for new applications we go to the public-facing materials, their website, their annual report, just to do that check. I would say the difficulty with this organization is we have a definition of civil legal services. And I think when activities fall in that middle ground, there is a little bit of a judgment call on whether it lands on the legal services side and the non-legal services side. So, and I think I did share this with patients specifically, that, the recommendation that came from the staff was something that I supported really strongly in terms of that itemization. Because of that, with that itemization, I think personally, as office director, I would have had a lot more comfort in that validation process. But however, I was not in the ERC, and I did speak to every single staff member that did in the ERC, and that this organization presented themselves very strongly, both the importance of work that they do and the nature of work they do. I think for myself, personal comfort in being able to have that itemization to do that validation for, and I would say not just for an organization of this size, but for any new organization that comes through that had more kind of, say, questionable activities, would give us a paper trail that that's happening. However, absent that, we do defer to our commissioners that are on the ERC. The recommendation is from them. And so that is a recommendation that you see from the memo. That's from patients and Bob. And I do think that speaking on behalf of the staff members that joined, that they support Bob and patients' recommendation is to not have additional documentation. But that's where we were coming from originally with the recommendation of getting more documentation. Not to say that they would not be found eligible, but it would give us that more peace of mind of that validation, that back and forth, because then we can then have the itemization between each of their program areas. What are those activities? What are those initiatives? How it was staffed? What is the monetary money that would come through that? So that we could just have a little bit more confidence in that validation. That will happen then at the monitoring visit, but it just wouldn't happen now.
For answering the follow-up question right there at the end, because like, do we get that stuff at the monitoring visit? And I think that's fair to note that like we'll have some mechanism later to validate against, even if we don't have it now. Yeah, we do. Our monitoring visits are pretty extensive. We send out program staff and monitoring staff. We ask everybody to open up their books, make sure that there's fund accounting. We trace it back. We interview clients, so it's very thorough. Just for a new grantee, I would like a little bit of that thoroughness done at the application, because once a grantee is in our community, we definitely want to give them more support and all that. So it's just a little bit more peace of mind of it. Some of that happened at the application level versus at the monitoring visit when they're already a grantee. Yeah, I think that might be a lesson learned, at least, from chair seat as you're talking through it, because, taking to the two potential logical conclusions, right? You bring in a grantee, there's some, call them wobblers, right? We're not really sure where they fall, and we're gonna pass them through because we think they fall well, we think they fall on the right side of primary purpose. And then we move through, and then we go through a monitoring visit, and it turns out that doesn't really parse out later. I mean, that doesn't work well for anyone, right? Like no one involved, including the grantee, is well served by that potential outcome. And I think your point is well taken, Juan, that an approach that in this stage for a new applicant that provides a more robust review, perhaps approaching or somewhat similar to what happens in the monitoring visit, would allow us a level of insight and comfort that there would be no less likely to be surprises that come up later in a monitoring visit. That might be something that we should approach systemically, especially if we're going to see more applications to pursue it. And sorry, Bob, I know you've had your hand up, so I'll turn it over to you to join in. Thank you for.
Yeah, I was just going to say that during the review, patients pointed out, I mean, this isn't a typical legal services organization like others that we fund. And one of the things that I felt is going to get them closer to the primary purpose was the fact that they seem to be tracking expenditures by contracts now rather than the specific provision of legal services. They do what they're required to under the different contracts they have. And so but when the oral description of what they do with those things sounded to me, at least, like it was provision of legal services. And so it raised my comfort level. I did not, going into it, this didn't seem like something that I thought we should fund, but after hearing them and the importance of the work and the strategies that they're changing and employing, it's important stuff, and I thought that they should be eligible.
Any other questions or comments about United Farm Workers?
I will just add, I mean, I also, Erica, like you mentioned, kind of, I think staff or others maybe like went to the public facing website, and when I saw the application, I was like, oh, this is interesting, and kind of had a similar initial thought to what Bob had mentioned. Like, this doesn't sound like, I mean, I'm not aware of any, like, you know, the legal services that provided, and it's there on their website, but I agree that, you know, I think in an effort, as it sounds anyway, in an effort to, you know, become a trusted organization in the communities served, it's not highlighted. Their legal services are not really at the forefront of what's put out there on their website. And I think in the scheme of what the work we do and the legal services community that does a lot of the work that we fund, you know, that kind of raises some questions like, well, is this even a legal services organization? Because they're not looking at, you know, the detail of the work being done, or how much, you know, is being spent on that versus something, you know, other work that's non-qualifying work, et cetera, et cetera. It's more of a perception thing, or creates this perception risk. And I think the legal service community in many ways looks to the commission and the state bar as part of our process to ensure that we are evaluating programs thoroughly enough to ensure that, regardless of what is put out there on the website, that the work is the work and the work is qualifying and therefore eligible to be funded or not, right? And I think that's an important thing relative to, so I'm not suggesting that the website be modified, but I think that I suspect that might be a place where others look at that and say, like, well, wait a minute, is this even a legal services institution? And I think, you know, it sounds like Patience and Bob, when you were speaking with them, that was revealed with a much greater degree of certainty during your conversation than perhaps the website would lead one to believe. And I think that's interesting, but I think in the grand scheme of the work we do, that's a variable to be mindful of.
Go ahead, Dawn.
Yes, and I was going to say, not having been in the ERC, but the way it was communicated to me that there was a really compelling reason why perhaps the website and their public-facing materials might not match ours. And, you know, there probably is a layer of, as we all know, with immigration work, that there's anxiety and kind of publishing that and like drawing attention. So that I think that's a very, very compelling reason to why there's a mix match there. I will say though, and that's why I had asked to advance that recommendation of having that itemization, because though the website might not, and for very good reasons like that, I do think it is important for us to have that itemization. That's me personally. So we do get asked, we can say, and I still am fairly comfortable with the ARs, with the recommendation from the staff team of not having it. I just do think, I do want to know, this is me personally, that it would have been better if we had that in case we get audited or we are asked, because then we have done a complete due diligence. And I think we still have with the ERC, but then at least it's on paper that this is what they have verified and have attested to for all these kind of activities broken down. That's personally where I think the staff recommendation originally, the thought behind that, not that ultimately would change it, but that we would then have that extra layer of documentation there.
I would suggest that the notes from the ERC meeting would provide that documentation. I was really impressed with the wide range of communication strategies that the organization used and how targeted they are. So, we're used to looking at a website and we think that tells us everything. Well, this is an organization that's got a TikTok strategy. It has a Facebook strategy. Some of it is monolingual in Spanish for certain audiences. And it's so I would warn against assuming that what appears on the website is somehow fully representative. But the notes from the ERC meeting point out all the different communication strategies and the ways they support the legal work. The impact report identifies legal services as the backbone of the organization, and really the organization has. I thought it was very effective the way they described how all of their work drives clients toward their legal work, educates the clients, and both about the organization and about the availability of services. So the concern about whether its principal purpose is actually legal work, I really feel that the record as a whole supports the ERC determination that it is. So, yeah. Selena.
Patients reference the notes from the ERC, and I think that especially when this comes before the full commission and it's a public meeting for which a lot of your grantees pay attention to that, I think it would help to have more information, because at my read of the memo, it doesn't look particularly compelling because the numbers have switched so much, and we're all aware that the more QEs you get, the more funding you get from a particular county. And I think that you'll have some skepticism from some of those grantees in that county who were just really curious how that number was established, the 59.97. So I think that if this committee is ultimately in support of deeming them as qualifying, I think the public memo may need a little bit of additional information. And also I heard someone reference that they are considering tracking their pro bono more carefully. And so if they anticipate applying for the pro bono allocation, that may also have extreme impacts on the distribution within those counties. And so just wanted to make sure that it's very solid that the work that they are doing is qualifying, and the pro bono that they're doing is for the qualifying work, because it could shift a lot of funding away from current grantees. And just, it's a statutory definition. Just want to make sure all the check boxes are checked.
I guess I'll just add, so the staff memo that was shared with the patients and Bob had a little bit more details in there than the memo that was posted, but not much more details than that. So if you're looking to have more information, obviously we're subject to CPR requests. All those notes are gonna would be turned over. I can't give you that confidence though that we go back to the staff notes. It's gonna give, and maybe it's in our understanding of how much more details, but that's why I was hoping for the itemization, because then you have a number attached to each of the activities. You're not going to get that from from the staff notes. But perhaps one of the staff, if Joyce or Alexa are on, can talk about generally what additional information that's in the staff notes that could be then inputted in the memo, so that everybody's really clear going into the commission what how it's going to be, how this can be beefed up a little bit, absent asking more. It doesn't seem like anybody has appetite to ask for more information at this point or go back to the staff recommendation, which I think is, that's all within your that's in your discretion. So we can at least share with you what we could add to that, so people are comfortable. But Bob, maybe you can go first while we elevate our staff members.
I just wanted to respond to Selena's comment. The pro bono was used in a different way during the conference. What they talked about was, as pro bono, was work they were doing representing clients who weren't eligible under the particular grants that they got. And so they were doing it on their own time. They weren't getting compensated for that. But one of the examples they used was somebody who is in the country lawfully, but was having some sort of immigration issues. And that person wouldn't have been eligible under the particular federal grant they were working under, but the staff people, the attorneys or the paralegals, continued to represent the person, even though they weren't getting paid. And so they called that pro bono. And so that was I don't think I heard anything that would impact the concern that you raised.
And Joyce and Alexa are both the staff members that joined that ERC. Jason, you wanna go first before?
Yeah, I'll just really quick. I mean, Dwan, you said it didn't sound like there was an appetite for additional documentation prior to the full commission meeting. I don't know if I agree with that assessment personally.
Okay. I just said I didn't know. It seemed nobody was saying that, because I would, again, that's still my preference. My personal preference is to get more documentation. But again, like this is obviously, it's not a staff decision. This is a committee decision. So it's the committee members.
Yeah, I mean, I would say that for me, I think from a transparency and confidence standpoint from our constituencies and knowing that we're doing the proper due diligence, I mean, I would be satisfied with that. And I think there's, like I was mentioning earlier, the risk that things come up. I mean, even if we move UFW Foundation forward and then start in the future, I do think that there's a need for us to figure out how do we apply the level of rigor that is similar to that of the monitoring visits before someone or a grantee comes in and has this impact and whatever, because I think the possibility of an outcome, even assuming everything that Bob and Patience heard at the meeting and assuming UFW Foundation isn't one of these potential organizations, the possibility that we could have all of this impact and then doing a monitoring visit and say like, oh, wow, we missed this. This is a big issue. And then have to basically move forward, but there's still that single year of potentially large impact. And that's concerning to me. And I would rather spend the extra time up front to make sure that we're knowledgeable. That's just me. But I also recognize that, as in my day job, like I'm the administrator, I'm the measure thrice, cut once kind of person. Like that's just my background. So I want to make sure that it's correct. And I don't say that, express that desire at all to diminish what Bob and Patience heard in the meeting and how it was conveyed. So I just put that out there that like I think there is an interest there, and I think it's part of instilling confidence in the greater legal aid community that we are doing the appropriate level of due diligence, and that the perception is that if we pushed it through as a commission, then it must have had that due diligence applied to it. And so that's just my take on things.
So I just want to say two things. One is I would be interested to know if staff has a serious doubt about this 59.97% number. And if so, are they thinking really it might be 40%? I mean, in other words, staff spent a lot of time, and we've got 10 bullet points here showing that staff was, back and forth. And as Erika Loman Corcoran mentioned, she said we've learned a lot. They're a new applicant, and clearly staff put a ton of time into this, for which I am really appreciative. But by the time it got to us at the ERC, I felt like this is a very highly competent staff, and this is a very highly motivated and successful. And when you step back, I mean, they haven't been an IOLTA applicant here before, but they have lots and lots, so they can make showings on every level of community support and success in their work and all of those kinds of things. It's a professional organization. These people aren't just starting out. So I felt like between the motivation of the applicant and the expertise of the staff and the degree of technical assistance that was provided, I would be surprised if we're talking about some significantly different number from 59 point whatever it is. So that's one thing. And the second thing is, it is really easy for us as commissioners to sit here and say, okay, you guys go and bring us back, spend another 30 hours bringing us additional data. And I think we need to be really careful about that. I am not suggesting, and Jason, I'm not hearing you say this, that, somehow like, sure, whatever, we're just going to throw a couple $1 million your way, whatever. I know you're not saying that. And that was the purpose of the ERC, was to determine whether or not and the degree to which we have confidence in the numbers. And by the time we were done, at least those of us who participated in the ERC had that confidence. What I would like to caution against is a kind of cavalier attitude toward staff time in the organization. This is, at the time we had this conversation, the plan was for the organization to turn around. We had the conversation on, the ERC was on a Friday, and the organization was supposed to produce by Monday another set of data points. And I think we should do a cost benefit analysis about that. How much question do we have about the organization's numbers? And if it's a significant, serious question, then by all means, let's get more numbers. But if it's just like, well, it might be 59.7% or it might be 58%, no, that's just, I don't think that's a responsible approach to the applicants who are coming to us, especially after clearly both staff and the organization put quite a bit of time and energy into refining the application to what I find now really ought to be a very high degree of reliability and credibility. So, and I guess there's one more thing I need to say, and I'm sorry to go on so long. If what we're going to do at these meetings is relitigate the conversation that the ERC had, I spent a lot of time on this back when, I read everything that came through. We spent, I don't know, a couple of hours in the ERC. And if we're going to, if committee work comes to the next larger body to be completely reanalyzed, then I don't know somebody will need to explain to me what the point is of doing the committee work to begin. So thank you for your forbearance.
So my comment was along the same line, is exactly what data would you be requesting, if any, and how much time would it take for that to be produced? And then there's the staff time to go back over everything. And I kind of agree with Patience, you know, is it worth it?
I can take a stab at that. And then I know Alexa's the main staff person, that she can chime in on her impressions and what other notes we can supplement to make the commission and you all kind of feel comfortable. I think what we were envisioning as a staff is having them go through each of their kind of program areas and itemizing their major initiatives and letting us know how those fall under our definition of free civil legal services, and then the staff time associated with that, the FTE and the dollar amount, because then we could have a little bit more of a granular approach. You know, they are a fairly large organization. So I don't think this is something that could be done in probably 1 or 2 days, but I would hope it could be done in about 3 or 4 days, and then we would take some time to review it. I will, before I turn it over to Alexa, this one was probably the hardest organization that we had discussions about, and this is why I don't know if there's unanimous staff opinion on this. I'll let Alexa speak to this because she's the one that reviewed the application. But we were of the conversation that you're hearing now in terms of you know, some commissioners wanting a little bit more and other commissioners feeling more satisfied at that. I would say that's probably exactly the conversation we've had internally with amongst the staff. So there is not, I would say this is probably one, to be completely transparent with you. We usually like to come to you with like a one staff position because it makes it easier. There is not that uniformity in our office amongst the one staff position. But I know that our leadership team, and I include Joyce and myself in that, we wanted more documentation to make us feel comfortable running the office. But Alexa, maybe I'll turn it over to you now to give your perspective with the technical assistance. And then I think the most important question at this point juncture, if we're not going to ask for more information, I think that's still a pending question. What would you add to the memo based on your notes to kind of beef it up?
Yeah, definitely. Good afternoon, everyone. Thanks for giving me the opportunity to chime in on this. So from my perspective, just having been the staff person leading this review, my initial impression with the low QEs, given that they were around the 20% mark and fluctuated throughout the TA, was really, I think, the nature of what can happen with a first-time applicant. I think there is a lot to be conveyed and understand in our application that might not necessarily be intuitive to some organizations. And I found that, like, for example, in their first iteration of their application, in one of the forms of the application, you're to remove pass-through funds, so funds for which you have no oversight of. And that, you know, if you misplace those and put them in the wrong portion of the application, can actually bring down your QEs significantly, which is why we remove them at the top. And, you know, as we did that and went through the motions of continuing that TA, that was something that was, there was pieces similar to that were being discovered, which is why in the memo you see various moments of TA in the form of emails and meetings and things like that. I was not the only person who I had tapped to kind of get their opinion on this. There were other colleagues on the fiscal team as well as the program team that I also you know, asked for their support and just kind of their eyes on. And by the time we got to the 59% that you're looking at now, we had seen their methodology of that pro rata basis, which I, from the program side, have been very familiar in seeing, and by that was confident in. And I think, however, I do understand the desire or the, you know, to have more information on that in the way of that itemization. But the conversation that we're having here today does sound exactly like what we were having internally. And I do feel like throughout the process, just given the extensive TA, that, you know, I am fairly comfortable with what, you know, what we've presented to you all today.
Joyce?
Joyce, did you want to go? Oh, you're on mute.
Hi, everyone. My name is Joyce, and I was also present at the ERC, and just want to quickly express my thanks to Alexa and the staff, and also the commissioners for all the work they've done with this organization. They're right to say that, you know, this conversation is exactly similar to in tone and spirit and the types of questions being asked that we asked in the ERC. I think what resonates for me is what Jason spoke about. You know, you kind of want to do as much as you can on the front end so that on the back end, when you get to the monitoring stages, you're not struggling to kind of understand what they bring in terms of, you know, sort of their qualified expenditures and all of those compliance pieces, having already taken the funds. And so you really don't want to be in that position. You don't want to hurt the other grantees in the pool and the community as a whole. And so I take that responsibility really seriously. I will say that, you know, aligned with the commissioners and the staff, like they provided very reasonable explanations for the multiple questions that we had for them and that we had laid out at the beginning. I think there are still lingering questions, and those were ones that, you know, I think Dawn and others have identified that we could certainly ask for more follow-up to. You know, how do the staffing numbers align with the number of cases and then with the total qualified expenditures? We could ask them to break those things down further for us if that, you know, would assuage some of the concerns. And certainly, you know, you want to balance that with the concern around, again, making sure at the front end that, you know, we're all on the same page and feel super comfortable about bringing them into the community. So, yeah.
But Joyce and Alexa, if we didn't ask for that, what other information are you going to add to the memo? Because patients said that there were a lot of notes and a lot of things that were said that maybe weren't captured in this memo. Can you speak to that so that we all have that comfort that you all did sitting in the ERC?
I don't know if this
Maybe
was
that's
something that
what it
we'd
was.
mentioned. Sorry to interrupt. There was one piece around staffing, which I'm not sure we talked about in this meeting yet, but they did, they had, and I don't remember the exact numbers, but there was a very small number of staff attorneys, which I think raised red flags, but they had also had a very large number of accredited reps, which they had labeled as paralegals. So it did, and I want to say there were over a dozen. I don't know if other people remember. I don't have the exact number to hand, but it made sense in terms of kind of the communities they were serving, as well as the types of cases that they were logging. They did a lot of, you know, I can't remember off the top of my head, maybe Alexa remembers, but a lot of affirmative things that, you know, don't require a qualified lawyer per se. So it was reasonable, I would say. So that was one of the things that we did talk about, but for the most part, I feel like everything that we have talked about today essentially covers point by point all of the pieces that we had discussed in the ERC.
Because my impression is like, for the people that participate in the ERC, Patience, Bob, Alexa, and Joyce, you guys have a lot more comfort in the recommendation. I think there's probably an element there that because we weren't there, and Patience, I apologize if this sounds like relitigating, but I do think this is a responsibility of this committee is to vet this before it goes to the commission, where I'm hoping it won't be relitigated, but you know, there is a lot of interest in this one, so that very may do that. This stands kind of muster at the commission too. So you all do seem to have a comfort that maybe some of us don't have. So I just want to make sure that that is captured. Like, you are telling us what that is, so we can capture in a written format, so that it's not just for the commission, so that the community has comfort that the commission has done its due diligence. So that's the piece I think I'm not quite hearing right now, so that we can bolster into the memo.
One thing I think could help is for the memo to be written in a way that reflects staff's confidence in the final number. I mean, I don't know if we can say that, because this is what I'm saying. Our staff doesn't, we're split on that. Alexa may have that confidence, but I can speak for the other staff. We don't have that confidence. Well, what I heard, and maybe I misheard, was Alexa, who provided the TA, has got a high level of confidence in the ultimate number. And so I really do understand how people who were not immediately involved in working with the organization, either during the technical assistance phase or at the ERC, I guess there's a reason that that this even got to an ERC and didn't just get rolled out at the technical assistance. And so I hear that there's not alignment among staff, and that different staff have different opinions. I take Jason's point about we don't really want to find out later that we made a mistake now. I'm also hearing, and I want to call this out explicitly, I'm also hearing a certain amount of gatekeeping on behalf of people who are already grantees. So I take that really seriously, the fact that this is going to be disruptive potentially for existing grantees. And I think we need, and in some ways that increases a sense of risk. We would insert these people into the formula, and then all of a sudden there's people who are getting reduced grants. And I understand why that feels like a risk. But I don't think it's, I think that our responsibility is not to other grantees. Our responsibility is to ensure that the statutory criteria are met. And I'm satisfied that the statutory criteria are met, and that this 59 point whatever percent, in the same way that the family law, whoever was previously, I mean, you don't have to be at 75%. And I have no reason to believe, based on anything anybody, that this is going to drop below 50. So that to me, I think, needs to be the question. Does this meet the statutory criteria? I think the answer is yes. And the likelihood that we find out later in the monitoring visit that it doesn't is very small. And it may be, I'm not sure it would be a problem for the doubt to be generated based on what other grantees in these counties might experience or their concerns. They are not stakeholders in this debate. I would urge us to apply the statutory criteria and look at what's before us. And when the time comes, I'm going to make the motion for approval. Alexa.
Thank you. Yeah, I think, Dawn, to answer your question about why I in particular feel comfortable with this, with their percentage as it is, in the ERC, I think Joyce pointed out that there is a large amount of their staff that weren't explicitly legal staff. And yes, 12 of those folks were DOJ accredited representatives. In addition to that, they had outlined some clerical and administrative staff and emphasized that they do in fact assist in the delivery of legal services by conducting intake, doing outreach, direct representation. And their community educators are also included in this, who go out into the field and provide legal information to their community, especially in hard to reach places, like the counties that they're applying for an allocation in. And as far as, other staff, they also do have, they outline executive director and accountants and have few explicit organizers, and did deduct for the organizing work, their out-of-state work, and their non-legal work that's outlined in the memo. So just having gone through the TA and gone through the ERC with them, I do feel like it was reasonable and sufficient in coming up with that 59% percentage.
I do want to support Patience's framework of this, because I do think this is not a discretionary grant. So if they are statutorily, qualifying, then I think we have no choice but to fund them. I think, though, there is, for me at least personally, still a question of whether that 59%, because I think their methodology to me sounds sound, but the methodology is dependent on their determination of what their application, I would say, of how we define civil legal services. And I do think it feels like the people that participate in the ERC feel confident in the application. Again, I'll say this for the last time, I won't say it again. It would just give me confidence that we could see that application itemized so that we all have that same application. And I do want to say something about we would put programs through this rigor, not because of the size. There's last year, there was an organization that also had a novel way of doing work and went through the same rigor, and we had them itemize it. And they're an organization that I believed got $500,000 in an allocation. So it's a fairly small organization, but what we're suggesting here is not because the dollar amount, their qualified expenditures is $9 or $10 million, but because of kind of the novel framework and the novel way that they're applying our definition of civil legal services. So I do want to emphasize that it's not because of the dollar amount, but it is because of the different way that they're doing it. Because as you'll see, you know, there's 6 organizations that came through. The other 5, the other 4, we didn't suggest an ERC because it was very like how their models of delivery were very traditional, and it was very easy for us to confirm that it was civil legal services. Because this one fell into that, that's why we're looking at it a little bit closer, but not because that their qualified expenditures is 9 million, and that wouldn't be consistent with how we've done it in our office previously. So
I want to make 2 comments really quick. Number one, I would respectfully disagree a little bit with Patience in saying that the other legal aid providers who are implicated by our review are not stakeholders. I think they are, because if we fail to apply the statutory standards effectively and do the due diligence, they're implicated, right? And so I think we do have a responsibility to them, as to all of our other, you know, the community and the people who the legal aid service providers provide service to ensure we're doing our due diligence and applying the statute correctly. I think that makes them stakeholders, and I think we have an accountability to all of them, and really, you know, the entirety of the state of California indirectly, right, to do that right. So, I mean, whether we want to use the term stakeholder, that's the right term or not, I think that's our responsibility. And to be clear, Patience, I don't think you're not doing that. I think we are. I think that's just how it all plays out. The other thing I think, you know, and Patience made this point earlier about relitigating. I do think there is a lot to be said for having this discussion, and then I'm really glad that those who participated in the ERC are here to kind of speak to what they heard and the confidence that they have in it, in the number and post TA, and you know, and hearing from staff that was present from Alexa and Joyce. And I think that gives me a level of comfort in moving it forward based on their analysis. I mean, we do the ERCs to conduct this evaluation, right? Like, that's why we're doing the ERC. And while I think there might be some lesson learned about the level of itemization that we might require as a standard practice for unique organizations, and how do we structure it, I'm not sure it would be reasonable to apply it at this stage post ERC, and kind of, I think that might risk falling into the relitigation that Patience is, you know, expressing hesitation about doing, right? If we want to create a framework that we say, like, okay, we're going to have a pattern and practice of here's how we're going to do this in the future, I think that makes sense. And we know that UFW Foundation, I mean, they've got representatives on the call. So on the flip side of things, the concern that I voiced earlier, and, you know, Joyce kind of echoed about, you know, you don't want to find out later at a monitoring visit that what we kind of had understood, and, you know, we had the verbal explanation, we felt comfortable, they're like, oh, wait, that doesn't really track later. I mean, I think to a large degree, UFW Foundation is here. If they weren't on notice that the monitoring visit would catch some of these things, if it didn't pass muster, they're certainly on notice now, right? And I think that they're likely confident that it will all track out. And I think if they're confident, if our ERC participants are confident that these numbers track out and will track out when we get to a monitoring visit, I think it's reasonable to move forward and pursue that way. Though I do think that there is something to be said for a greater I would say perhaps more structural approach to, how do we have the ERC equipped with enough detail to clarify these kind of questions? I mean, I don't think UFW Foundation will be the last organization which has a unique framework for delivering services that doesn't quite fit into the easy to approve. I mean, that's why we have the ERC as the primary purpose evaluation, and why it's so flexible is that these things are going to happen. So maybe part of this is we should have a secondary issue later, or staff can kind of come up with a framework like, when we have these kind of organizations, we should ask for itemization. We should get that stuff so that when the ERC is done, it's being done in the context of an itemized thing. And there's a little bit more rigor. And then the memos will reflect that rigor, which means that our stakeholders will see all of that and be like, okay, it makes sense, right? I think that might make things kind of move along more smoothly. I think my position would be to agree, at least in spirit, with kind of what Patience is saying. Like, I don't think that right this moment is the space to apply that rigor, right, post ERC at this stage. I guess that's my intake. And Selena, I know you had your hand up, and then.
Well, my comments are quite quick. I mean, the statute is the gate. And so that's and then y'all's job, of course, is to interpret the statute, and the State Bar staff gives a lot of support to make sure that you have the information you need. So I don't think anyone is trying to be a gatekeeper, but we all understand that we want to make sure that organizations are reporting the information that's helpful. And to Dwan's point earlier about, a novel way, I think that, the way that UFW Foundation is providing their services is really interesting, but one of the organizations that applied with a novel, I guess, way to deliver services, they are not applying for IOLTA funding this year. And so I think it would help UFW Foundation to know the kind of data that the State Bar staff is looking for. And maybe in their first year, they may want additional technical assistance just to make sure that they are giving everything they need to commissioners. And another organization that was new last year, again, another one did not apply because, there were some issues that came up in monitoring visit that they may not have been aware of them earlier on. And if we have new IOLTA funded organizations, I think more technical assistance earlier on will just set them up for success. But I do worry that this may be the exact same discussion we have at the full commission meeting. So I think a memo with more information on why this committee is making the recommendation will make that conversation faster and easier, and hopefully painless for UFW Foundation.
I will do my best to try to channel that as chair as well, to try to accelerate the discussion at the commission. I don't know how much success I'll have, but I'll certainly try. Go on.
Yeah, I just want to say, since Patience and Jason are both on the executive committee, this is probably one that we should probably talk about in concept of things that we want to do structurally to change. Because one idea that we bounced around internally, and I've had conversations with Selena about this too, is that perhaps I don't know, we could do this without a statutory change, but doing a monitoring visit as a means to qualify for our grant is one thing that you could do preemptively. And then just, again, I know I said the one thing about last itemization, I know you guys don't have the appetite for this, but we actually, part of our process when we do this is to actually require programs to do the itemization. The reason why this didn't get done before the ERC is because we thought it wasn't necessary when they were below 50%. And then when they came back over 50%, it was like a couple days before the ERC, so we didn't feel like it was appropriate to then ask them within like a couple. So we thought that the staff recommendation was going to be a mild recommendation, and because it was going to happen before, but it didn't get a chance because we weren't notified that would be over, that it would happen at the end. So that's why that's out of process. It is actually in process for us to when the staff. It's the timing of this, as you can see, there's like some wild swings, and Alexa has been working on this very, very hard in terms, you heard about the technical assistance. The amount of technical assistance that she has provided to this organization has been phenomenal. I mean, she even worked when she was on vacation to provide. So when we got the last minute like swing that was 59%, we didn't have an opportunity to ask for the itemization, and that's why we wanted it after the ERC. I actually didn't think that recommendation would be that controversial of having the itemization, but that's why this one would be unique and us not having that itemization for novel, because we did make Legal Link do that itemization last year very granularly because we knew more preemptively that there was going to be that issue. But I hear you, and that structurally maybe now it might feel like it has been too late. But I guess moving forward, then there are probably things we could do. And maybe it was one of those things, but we should have just probably moved the ERC so we would have had that information going into the ERC. But I don't know if there's much more to beef up. I know that I can't remember who said that, Selena, about adding more, because what I'm hearing from Joyce and Alexa, other than what they additional information about the accredited reps that they just shared, there's not much more that we're going to add to that. But maybe it's more procedurally that you want us to capture the conversation here, because I don't know if factually there's anything more to add that I'm hearing.
I think that sounds right, Dawn, that it's just capturing the discussion, the kind of experience from the ERC, the discussion we've had today about, yes, there are some hesitancies, here's what they are, here's why we're moving forward anyway. And, the suggestion from Selena about let's make sure we're very keen on technical assistance relative to our grantee coming in, especially given all of this, and the technical assistance that went into getting to here. I think highlighting the TA will serve well the comfort level at the full commission level, right? To see okay, well, this is a result of all of this post TA work, and to your point, Juan, I would say. I would probably recommend that in this circumstance, if the additional itemization was part standard, that probably delaying the ERC to get it if there is that swing.
Yeah, in hindsight now, that's probably what we should have done. But it's a very tight schedule. That's the thing, as you all know, to hit everything and then to set up, and it's very hard. But I guess if we have that mindset, that's even an option, then maybe in the future we would have forced the itemization before we walked into the ERC.
Yeah, and it probably didn't.
Yeah.
Some of that happened probably when I was fully out of the country, so you couldn't ping me and say,
yeah, it's okay. I think it is. It's just honestly we didn't think we would be where we're at with this particular applicant. So
this is how we learn, right?
Yes.
Go ahead, Joyce.
Hi, just to close out, I guess, this conversation, assuming it's closed out. I do want to mention that at the end of our ERC, we all agreed that UFWF would be getting a lot of technical assistance, that this initial stage of application wasn't going to be the end of our conversations and support of this organization, that were they to be deemed eligible, they would be getting a consistent and high level of support from our team, so that by the monitoring visit, we would know more. In other words, we wouldn't suddenly be surprised at a monitoring visit by what they shared. So that was always the intent, I think, from the group after that meeting, and throughout that meeting that was discussed.
Well, and there are some structural things that we'll do, and I don't think you guys know this, but for our new grantees, when we go on monitoring visit, we tend to do it in that Q3, Q4. But there's been discussions in the last few years, because by the time we do a Q3, Q4, the application period would have been over for the next year. So you're actually effectively a 2-year window. Whereas maybe the practice should be to have a monitoring visit probably Q1, Q2. If there are concerns, we can catch it before the next application and bring it to you all. So that we can do those structural things, and that's something I think Patience and Jason, we could talk to the executive committee and get their thoughts. I think those are probably good discussion points.
All right. So as we wrap up, I think that's a great point to wrap up, Dawn. I know that Patience had expressed an interest in making a motion. So I'll kick it to Patience so that she can do so.
Thank you, Jason. So I am moving, this is still slide 11. Further resolve, the GES committee recommends the LSTFC find the following 2026 IOLTA EAF applicants eligible for funding, dependency legal services, and United Farm Workers Foundation.
I will second the motion.
Can you go ahead and take roll?
Yes. Are you able to hear me? I just got a notification that my internet was unstable, but are folks able to hear me?
Yeah.
I can hear you.
Okay, great. Gonzalez,
Yes.
King,
Yes.
Klein, Milrod,
Yes.
Pryor,
Yes.
Stalker,
Yes, abstain with respect to dependency legal services.
thank you. Belkin, sorry, Jason, I don't know if you,
I said yes, sorry, I will enunciate more.
thank you. Okay, that's 6 yeses, 0 noes, 1 abstention, motion passes.
Thank you, everyone, for the robust discussion on this. I know it was a sticky one, so I appreciate everyone's efforts.
Great, thank you. And so moving to our next eligibility review conference, the last one that was held was with the Sutter Legal Center for Seniors. Yuba Sutter is a former grantee reapplying for 2026 IOLTA EIF funding. Their last year of funding was 2024, so they were found ineligible for 2025 grant funding after failing to provide an audit by the extension date that was granted by the commission last year. Just a little background on the audit requirement. Audits are due May 1st of every year. Staff has discretion to grant an extension until the IOLTA EIF application deadline, which this year was May 15th. Audits are required as part of a timely and complete application, and they are an integral part to application review because they are the basis for calculating total corporate expenditures, which then deductions are made from that total to achieve qualified expenditures, which in turn go into the funding formula. And so audits are really the starting point for that entire process. So they are an important aspect of the application. This year with applications, applicants were reminded in mid-April that they should let staff know if they can't make an extension deadline of May 15th, which is the staff discretion deadline. And if they needed more time, that they should submit a written request to be reviewed by this committee, which for the ones that did submit timely, you all reviewed that at the last, at a prior meeting. In the case of Yuba Sutter, we received an initial request on May 16th, which was after the deadline. It was incomplete, and we had to ask them to revise and resubmit on, which we received on May 23rd. So they currently have not provided a reviewed financial statement or an audit. The organization had requested an extension to July 26th. And so the purpose of the eligibility review conference was to assess that failure to submit a timely reviewed financial statement, as well as to discuss a history of audit findings regarding the organization's internal controls and a pattern of late submissions of reports to the state bar. And so the discussion at the ERC, the organization explained that it had had trouble finding an auditor, that the auditor they used the prior year said they wouldn't be able to complete the financial review until the end of the year, which would be well past the deadline, that they went out to seek other audit firms that could assist them and had trouble engaging anybody during tax season. And so finally they were able to find a new auditor, but did request this extension to July 26th. The discussion around repeat audit findings was that Yuba Sutter's prior financial statements that had been received for prior grant years in 21, 22, and 23 were audits that identified significant deficiencies on their internal control procedures. So there were issues with things like their time card documentation of accurate pay rates, time cards lacking the total hours, untimely deposits, bank deposits, insufficient documentation to reconcile employee timesheets to their grant and contract billing, and reliance on the auditor to draft financial statements rather than providing prepared financial statements to the auditor. So Yuba Sutter had acknowledged those recommendations in prior years and committed to implementing corrective actions, but given that these findings were repeated year after year and we don't have a current version of their audit to show that it has been resolved, it raised questions about these ongoing issues or the potentiality for these ongoing issues. And then the team also discussed late submissions. So in this reporting year, based on other grants or prior year reporting that had to be submitted to the State Bar, the State Bar has received 6 late reports from this organization that came in anywhere from a few days to almost 3 weeks late. And the explanation that was provided was that the organization has been having staffing challenges and thus having challenges meeting some of these deadlines. And so those were kind of the 3 major issues, was that audit deadline and explanation for it being late, the internal controls issue, and the late reports. And during the discussion with the team during the eligibility review conference, they found that the organization was inadequately prepared to really get into deeper conversation about the identified concerns, and didn't feel that the standard under the rule is that an organization needs to show extraordinary circumstances to get an audit extension past the application deadline. The team didn't feel that extraordinary circumstances were demonstrated. In the absence of extraordinary circumstances, the commission can still grant an extension, but would typically impose conditions on the organization to ensure that this type of activity is not repeated in the future. And so the team ultimately, after discussing and reviewing the documentation that was available, was recommending approving the audit extension request to July 26th. We're already almost here, but only approving it, obviously, as long as the organization actually submits that finalized board-approved financial statement from the prior fiscal year. Because it was not, there were no extraordinary circumstances here. There was also a recommendation that the commission would likely impose conditions on Yuba Sutter if we do receive a final audit. But those specific conditions would need to be formulated after reviewing the audit and determining what issues may still exist. And so those would be, if this recommendation is approved, the conditions would be presented and recommended at the commission meeting in August. And so, yeah, that's pretty much in a nutshell what the outcome of that eligibility review conference was, and the recommendation to give the extension. And then if they achieve, or if they meet that deadline of providing a final audit, that staff will review and report back on what conditions might be appropriate under those circumstances. And then, of course, in the absence of meeting this deadline, the recommendation would be to find the organization ineligible for 2026 funding because, as mentioned, the audit is an essential piece of the application and cannot be waived. So I think Angie and Judge Klein were on this review conference. If either has any additional thoughts or if there are any questions about it, happy to take those.
I think you captured the gist of it. Of course, the judge has gone off on vacation and left me to field the whole mess, but it is kind of a mess, and that was our big concern. And in the case of United Farm Workers, you guys found a high level of confidence because the staff appeared professional and they had all their ducks kind of in a row, and they had an explanation, and they were reasonable, et cetera, et cetera. I at least did not find any of that with the Yuba Sutter discussion. It's kind of like the staff people that we interacted with were not even aware of what the reason was for our meeting. They didn't really address a lot of the concerns. So I'm curious to see if they do, in fact, turn something in by tomorrow and what it looks like, but we won't know, and that's all I can say. If anybody's got a question, I'll try to answer it.
So this is less a question, but more of a statement. And I'll double down because I'm a former resident of Sutter County, and it's frustrating. But I was also on the committee when they missed the last, they were pulled off because of the failure to do the audit work. So, it's concerning because while I recognize and appreciate that it's tough to find an auditor, from a timeline perspective, it's concerning because it's not as if, like, I feel like it's deja vu all over again. Like, here we are late on the audit. The audit's important. And I mean, hopefully, I know Joseph was here earlier, and he still might be, because he said he was going to stay through his item. But, you know, it's tomorrow is their target date, and he said we'll have it tomorrow. So, you know, I think if we're already talking about it, extending a day is not a big deal. But I think if they fail to do so, it's going to be an issue. Like that seems to me like that would be it. And I agree with kind of the suggestion that you can't really figure out what conditions, if any, would be appropriate until you see the audit to figure out what conditions would be appropriate, if any. But I have some concerns that it seems like we're back to where we were, and I really want to be confident that regardless of conditions, that we won't be back here again a year from now. I want that to be the case, and I will say I want that to be a case both because I have lots of colleagues and friends who are in the Yuba Sutter area, but also because Yuba Sutter is one of the few programs providing services in a decidedly rural part of the state, where there is an absence of legal service providers. And I think it's really important that we have those services. So I think they provide an important service. And so I want to see this work out and get cleaned up. And I think it's just doing business with the state bar to get grants can be a complicated administrative endeavor. We all know that. But it's the hoops that we have to jump through to make sure it's all done the right way. And I hope this is the start of a process where we can get things lined up and we have the audits done consistently with reviewed financial statements and all the things we need, and that this is the beginning of a new leaf turnover. But I am hesitant and concerned as a result of the kind of the history, and so that's my thought.
I just want to share that, we support the committee, the ERC's recommendation to approve this, grant the extension to tomorrow. But I do want to underscore there is a real impact on our staff to be able to do this. As we mentioned, we noted in the memo, usually these applications are very technical. They take several weeks, sometimes a month. UFW took more than a month to kind of review. This one certainly is one of those. We cannot even do the review until we have the financial statement or audit in hand. So I'm going to have to ask my staff, Mikey, who's on right now, that reviewed it, to be able to do that on top of he's managing our partnership grant application. This is a heavy ask for our team, which we are doing and support the recommendation. But I don't want to highlight that because it's going to impact our staff. And then the other thing that you heard me mention earlier in the meeting is like we preemptively run the formula so that we can do it all correctly and do the check, because there's like pending things going on. I still have confidence we're going to run it correctly, but it delays everything for us. And that's why in past years, the drop dead deadline was the middle of July so that we could hit that. We are now deviating from that drop dead deadline in order to be generous, because it is an area of the state that's in such need, but I don't want to make light of the fact that it does have such an impact for our team.
I see that Joseph has his hand raised, if you would like to hear from him again.
I mean, he offered public comment earlier, and since we're on the action item, he would like to toll his time and take it from here instead of just saying he was here. I'm happy to give him a couple minutes to comment in light of what we're reviewing.
Maybe he could give us an update as to how likely it is that there will be something turned in by tomorrow.
Can you hear me?
Mhm.
Marilyn Monroe, she spoke with or communicated with the auditor this morning, and it's my understanding still expected to be received tomorrow. I do have one question on the board approval element, as it was my understanding when I spoke with Michael Chong about board approval being required, that was a $500,000 or more budget. And if that is still the reason for that on this, or if this is an extra requirement, because I probably can get that done, but it adds a hoop to jump through tomorrow once we receive the audit.
Mr. Carrico, we did emphasize for you in the ERC that it needed to be board approved. I think we can all confirm that on the thing that's not a new an additional requirement. In order for it to be a final financial statement or audit, you're not required to submit and audit it, but because you're below 500,000 expenditures, you submit a financial statement in lieu of that. But to be final, it needs to be board, and we did underscore that a few times during the ERC.
Okay, I wasn't certain of that. We can have it board approved, and on Monday morning, everything would be all dots.
Well, the recommendation that's on the table now is for the final submission on Saturday. That is the motion. So if you're submitting it on Monday, it's technically late, and we haven't even taken the vote yet of whether we're going to do that. But it will, if you're planning on submitting on Monday, it will be
We could be submitting it tomorrow, but the approval, if it came through tomorrow or it came through Monday, how would that change anything?
We were assured from you and your staff member that was on that you can get that approved on Saturday. We did mention the same thing. It's coming on a Saturday. Are you sure you can get a board approval? And you and your staff did confirm, and I have
I believe you can. I just wanted to double
was
check that
happening on the
element.
Saturday.
Yeah, but I still believe we can. But I was just confirming that element now, because my understanding it was income related, but I guess it isn't. Okay, thank you for that clarification. But the auditor has indicated that it should be timely. And they are in the Eastern time zone, so I would expect it to come through earlier than later in the day. Thank you.
Thank you, Joseph. I would highly recommend, given the timelines that we're talking about, and if you expect to receive from the auditor tomorrow, and we need to get it by tomorrow, making sure the board is lined up to review and approve the audit so that we can get it tomorrow, so that all is
So we had a meeting earlier this week, so.
Well, thank you for your comment, and I think that's all of our, unless there's other discussion.
I think if there are no other questions or comments, given the committee's been wanting to take these motions one at a time, I'm happy to read the proposed motion if that's helpful.
Yes, please. Thank you.
Sure. So the resolution related to Yuba Sutter is that is resolved that the GES committee recommends the Legal Services Trust Fund Commission approve Yuba Sutter Legal Center for Seniors audit extension request to July 26, 2025, with conditions formulated after staff review the complete application for eligibility.
If that's the motion, I would move it. Move approval.
I'm sorry, I would like to amend it just for avoidance of confusion, that the approve Yuba audit extension request, board approved audit extension request. Let's put it in the motion. There does seem to have been some confusion for reasons that are not clear to me at all. But I would respectfully request to amend the motion to approve board approve before the word audit.
Should we say final board approved? That's, I think, the language that's in the memo itself. So it's
better.
Clear.
That's okay. I'd accept that.
Have a motion, looking for a second.
I second.
All right.
Crystal, can you take roll, please?
Yes. Gonzalez,
Yes.
King,
Yes.
Klein, Milrod,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Falcon.
Yes.
Okay, thank you. That's 6 yeses, 0 no's, motion passes.
Thank you very much.
Thank you. Then our next topic regarding eligibility is the pro bono allocation requirements and the applicants. So, as you all may know, 10% of the funding in each county is set aside for qualified legal services projects that coordinate the recruitment of substantial numbers of private attorneys and provide services through pro bono as their principal means of service delivery. So a certain amount of funding on each county is set aside for these organizations specifically. Under some new state bar rules, the requirements for applying for the allocation changed a little bit. So historically, we had 3 ways of becoming eligible. That you had more volunteer attorney hours than staff attorney hours, just based on it. That's a quantitative method. Another was a larger analysis of overall volunteership. So we would include things like volunteer paralegals or volunteer law students in the analysis. And then the third way of qualifying was through a narrative where the organization explained that its principal means of service delivery was through pro bono. That narrative previously didn't have specific factors outlined or requirements beyond that the organization needed to discuss or to demonstrate principal means. And so the purpose of these rule changes that went into effect last year are to basically lay out various factors, both for meeting substantial numbers as well as principal means, and to have all grantees who are applying under a narrative method have the same, reference point for what they're discussing for the committee's consideration. And so we now have 2 ways of applying or establishing eligibility for the pro bono allocation. One is that quantitative method I mentioned. So we've preserved the ability to demonstrate, if you can demonstrate more pro bono attorney legal services hours over your staff paid attorney legal services hours, then you qualify. And then those who need to go through the narrative description, walk through the factors in their explanation of both substantial numbers and principal means. And so it's this method 2 group that is being presented to the committee today for your consideration. Those who satisfied method 1 are already deemed eligible for the allocation. And so we have 21 total applicants for the pro bono allocation. Something I didn't mention is that you have to establish eligibility for the allocation in each county. And so the analysis, for example, is how many pro bono attorneys did you have in this county and how many hours of service in this county did they provide? And so we have 17 returning applicants that already received the allocation. We have 4 new applicants. Those are Inner City Law Center, Riverside Legal Aid, Social Justice Collaborative, and Ventura County Legal Aid. 8 of our applicants are eligible through method 1, serving a total of 14 counties, and so they are deemed eligible. And then we have 14 who applied through the narrative method 2, and they're serving a total of 9 counties. 7 of our applicants either didn't receive the allocation at all this year, but those were the 4 organizations I just mentioned. And then we also have 3 organizations that are expanding the counties in which they're applying. And so Justice and Diversity Center of the Bar Association of San Francisco is applying in 5 new counties, and they qualified under method 1. Lawyers Committee for Civil Rights is applying in 2 counties under method 1, and then 1 county under method 2. And then Veterans Legal Institute is in 2 new counties under Method 2. So as part of your meeting materials, we included the list of organizations that are applying, as well as the method under which they are applying and all of their counties. And so this is the first half of the applicants. The next slide has the others, but we provided you with the narratives that they listed as well. And so they went into detail, for example, the number of attorneys they recruited, their recruiting methods, their curriculum, the number of hours donated or the value of donated services compared to their own expenditures, those types of things. So the narratives that we received many of them are quite a bit longer than maybe they were historically, and provide more detailed information for the committee's consideration. But if you have any questions about specific organizations, we're happy to try to answer those. But otherwise, these 2 slides contain the full list of applicants. But staff didn't have concerns about the narratives that were presented, and so we are recommending that all of the applicants under Method 2 be found eligible for the allocation in the counties where they're seeking it.
Assuming there are no questions or comments, should we move towards a motion?
Sure. We can bring that up. Sorry, 1 second. Okay. So the proposed resolution regarding the pro bono allocation is that resolved that the GES committee recommends the Legal Services Trust Fund Commission find the following 2026 IOLTA EAF applicants eligible for the pro bono allocation under Method 2. And it lists the organizations: Betzedic Legal Services, Casa Cornelia Law Center, Harriet Buhai Center for Family Law, Inner City Law Center, LACVA Council for Justice, Lawyers Committee for Civil Rights, Legal Aid Society of San Bernardino, Public Counsel, Public Law Center, Riverside Legal Aid, San Diego Volunteer Lawyer Program, Social Justice Collaborative, Ventura County Legal Aid Incorporated, and Veterans Legal Institute.
I would welcome a motion to approve.
I'll also move.
I'll second.
Crystal, do you mind taking roll, please?
Gonzalez,
Yes.
King,
Yes.
Klein, Mulrod,
Yes.
Pryor,
Yes, abstain as to Ventura County Legal Aid.
thank you. Stockard,
Yes.
Falcon,
Yes, and abstain as to everyone who does work in Riverside County, because there's a handful of them.
okay, thank you. That's 6 yeses, 0 nos, 2 abstentions, motion passes.
I would like to make a secondary motion if we're, actually, wait, are we still have more on 4.1?
Yes, we just need 1 more motion on sort of the overall eligibility recommendation.
I'm going to make a suggestion that after we close up 4.1, we take a quick break.
Sure. So the final proposed resolution is that the committee recommends to the commission, this is the second resolution here, that the GES committee recommends to the Legal Services Trust Fund Commission that they find all other applicants listed in attachment G in your materials eligible for 2026 IOLTA EAF funding. One thing I'd like to note is that we did, in the materials that you received in attachment G, it lists 120 organizations. We have had 1 organization withdraw since we posted those materials. And so when we bring this to the commission, we will be removing that organization, but the rest of that attachment is correct.
I would also invite a motion here.
So moved.
I'll
I will
second.
second the motion.
Go ahead.
I'll second the motion.
Crystal, can you take roll, please?
Gonzalez,
Yes, but abstain as to the Family Violence Law Center, Legal Access Alameda, and Legal Assistance for Seniors.
okay, thank you. King,
Yes, and abstain as to the San Luis Obispo Legal Assistance Foundation.
okay, thank you. Klein, Milrod,
Yes, abstain as to Central California Legal Services.
okay, Pryor,
Yes.
Stalker,
Yes.
Falcon,
Yes, and once again, abstain as to those doing business in Riverside County.
thank you. That's 6 yeses, 0 nos, for various abstentions noted, motion passes.
And
Thank you very much. Thank you, Erica.
sure, I'm sorry, I did want to provide one quick update. This is a non-voting aspect of eligibility, but I did want to let the committee know that we finished the deeming process recently. So support centers that weren't in existence as of December 31st, 1980, they need to be deemed of special need by a majority of the qualified legal services projects. And so our office practice is for those support centers that have to go through that process is we send out ballots for them every 3 years, and it's sent to current year qualified legal services projects. So this year we only had one support center that required deeming. That was Center for Gender and Refugee Studies. They did achieve a majority vote from the qualified legal services projects. We had 69 of 92 QLSPs responded, and the organization received 62 yes votes. So they were deemed for the 2026 year, but just wanted to provide that update because this is also part of the eligibility process, but doesn't require committee vote.
Thank you very much, Erica. Appreciate it. I will say we can take a quick break, maybe like 5 or 10 minutes. Do people need? 10? All right, patience calls for 10. All right, approved at 10 minutes. We'll see everyone back here in 10 minutes. Thank you, everyone.
Can I do that without reopening the whole mess?
Yes, I believe so, because we have enough other votes. I'll just ask that Crystal make note of your abstention.
Thank
We
you.
actually, I think probably when you joined, I know when I did, or later, Brady had done a whole, State Bar had done a whole list of like organizations that you have conflicts with, so there's an ongoing note of it.
Okay.
So there's that too. The State Bar does a pretty good job of trying to make sure that all of us who volunteer with our local constituencies and connections, that we are abstained or removed from having an impact.
Thank you.
All right, well, I think we are waiting on Patience and Selena to return. You're muted.
I apologize, but you can always start without me because I'm just a liaison.
Fair enough.
I appreciate the bio break.
Yeah, I was getting close there too. I was like, we are not getting through the rest of this agenda before a bio break. I need to take one now. So without further ado, I think we will move to action item 4.2. And that is Mikey. Sir, take it away.
Hello, good afternoon, commissioners. My name is Michael, and I am here to present on agenda item 4.2, approval of the 2026 partnership grant funding recommendations. There is an update. We were just notified of additional funds. So have shared that information. I've updated the table so we can walk through what that looks like, but did want to share that. So what I'll do now is I'll share screen. And then we'll go over the talking points and do all that good stuff.
Mikey, can I just chime in just for some clarity for the meeting? The additional funds Mikey was referring to are the projected filing fees. We were getting confirmation, and the memo that was posted had a conservative filing fee amount. We just received confirmation from Judicial Council this morning that that amount is larger. So the scenario Mikey will now share has a larger total, but that's where that additional funding was compared to the materials that were posted yesterday.
And Mikey, before you launch into the word recommendations, did you want to give a little bit background on what partnership grants are and like maybe the scoring team, what you all did, the process?
Of course, sorry. Yeah, so just definitely you have all that information in the memo, but just a couple highlights. Partnership grants are are collaborative projects between California courts and qualified legal service providers. The point is to assist self-represented litigants in civil matters. This year, we received 43 applications that requested a total of 7.9 million. This grant is oversubscribed. The estimated amount that we currently have is 6.1 million. And the individual funding requests range between 46,000 to 400,000 per project. Projects proposed will span over 17 counties, with most in LA County. The areas of law focus were family law, domestic violence, housing, and consumer finance. So for the 2026 scoring, we had a scoring team that included 2 Legal Services Trust Fund committee members and 3 State Bar staff. We did calibration on June 12th with our subsequent scoring sessions on June 18th and the 24th. After all the proposals were reviewed, the scoring team developed 3 funding scenarios, which recommend the 35 projects who received at least a score of 65 points. And then I can dig into what that looks like now. Can you all see my screen? Is it big enough? Perfect. Great. So just kind of walking through, we did come up with the 3 scenarios. On the right, I do have 2 scenario Cs, the old one plus the new one with the confirmed additional funding. But ideally, generally speaking, scenario A sets a $250,000 ceiling and provides full funding for smaller requests up to $75,000. There is a tiered percentage of funding based on the scores, and depending on how they got their scorings. And then for scenario B, it raises that ceiling to 275,000, but there is a little bit more restrictive threshold in order to get 100% funding or 97% funding. Instead of having to hit 77, now you have to hit 85. And then scenario C, which is our recommendation, that maintains the $250,000 ceiling, but it's also a little bit more simplified. Any grantee that received 75 points or more received 100% of their funding up to 250, with the caveat of the top scoring group, and then it just declines based on percentages. What I do want to highlight here is with the additional confirmed amount, we were able to bump up the percentages at each tier just by a little bit more. So instead of 85, it's now 95. Instead of 80, it's 90, 85 to 85. Pretty much the reason why we're recommending option C, it provides the most number of grantee or projects to be scored at 100%. It also provides a good variation of different projects. So yeah, I can take questions.
Sorry, can you repeat for me? You may have mentioned it, but I missed it. What was the final amount of the additional amount that we ended up getting?
It's 6.1 or 6,182,838 compared to the 5 million.
Thank you.
It's not that big of a difference. It's they're giving us the whole filing fee, the cap, and we had projected 200,000. We're getting about 500,000.
I mean, that's a non-zero amount. I'm sure it's something for our grantees.
Yeah.
Selena.
I like staff recommendation to fund more organizations closer to 100%. I think that that's helpful for programs who have put together a budget and have considered the staffing that is needed for these projects. And also working with courts sometimes requires a little bit more people time. So it's good to be able to provide the people time. I do think it may be helpful for the organizations that barely missed that threshold, because that threshold was, although a natural number to y'all, so there are several organizations that are quite close. They may seek some feedback to find out what could have gotten them a little bit closer. I've heard from a lot of organizations recently when they weren't selected for a competitive grant, they're asking for more feedback so that next time around they can have a stronger application. So if there's an ability to do individual feedback, which I know is a lot, but if there's an ability, I think they would really appreciate that.
Agreed. I'm happy if they want to reach out. I'm happy to provide that feedback based on what we discussed during the scoring and looking at the strength of their materials. We can definitely do that. They can reach out to me, and I'm happy to schedule some time.
There was also, I think, a few, at least during the sessions that I worked on, where, I mean, we looked at the concept and what was there, and, some of the workup in the application, didn't really get where it needed to be. But it was definitely one of those like, hey, next time you would definitely score much better if you shored up your work in this area. And we talked about potentially sharing, highlighting, like, this is what we're looking for, something like this, right? And so next time you go about it, there were a few where, on the administrative side or some of the other areas of evaluation where it's like you either are doing the thing or you're not doing the thing, or you're documenting it or not, where I think we felt that, or I felt when I was scoring, like, well, I can't really give you points, or a lot more points in here, but it seems like there might be something that you could document. And that's really not necessarily about what you're doing. It's about you articulating that you are doing the thing that you need to be doing and how to present the application. And I, like you, Selena, don't want to see applicants score poorly because they're failing to effectively articulate what they are doing, as opposed, it's one thing if you score poorly because you're not doing the thing you need to be doing to score well. It's another thing if you're scoring poorly because you're not articulating it in your application. We want to make sure, at least for assistance there, that we're making sure that people are putting forward their best foot forward, right? And that's important. So we did talk about that in my sessions. I think there were a few actually that popped up where it's like, oh, this is going to score a lot lower, and it's so close that, like, if you just done A, B, and C, like, I could see this being almost 10 points higher. And that's kind of a bummer in the process, but it is competitive, so you can't pick favorites and whatever. But your point is well taken for sure.
I do also want to add that we did have office hours in the beginning, so that is an opportunity for organizations who have questions on what the application is requiring of them to show, to come and then talk during those office hours. Cool. So if we don't have any other questions, I guess these recommendation would be that if the GES committee concurs, it be resolved that the Legal Services Trust Fund Commission Grant Eligibility and Support Committee recommend to the Legal Services Trust Fund Commission that it approves the 2026 Partnership Grant Awards as described in Scenario C. And then we can, since there is a little bit changes there, I just want to make sure it's all captured.
So moved.
I have a really quick question. I'm sorry. Scenario C, is that column J?
Yes.
Okay.
Again, we had an original with the lower conservative amount, but now that we got confirmation of the total amount, this is going to be the recommendation here.
Can I make the recommendation, Mikey, that for the resolution language, we be even more specific and say something like, as updated during the meeting or something, just so there's just like, you know, for a year from now, there's no confusion about whether or not it was scenario C as posted, which I understand is a little different because the total amount of funding was a little less versus what you're sharing on the screen right now, which is the same schema, but has the slight adjustments to the percentages and the greater amount of funding that's feeding into it. So something like as staff presented during the meeting or something, just like a little clause.
As presented during the meeting, July. Is that okay?
I think you deleted too much. You want to still say the column C?
Yeah, I would still specify scenario C in there somewhere. Yeah. As presented in scenario C during the meeting on July 25th, 25. Something like that, I think will just be a little bit more precise.
During the meeting, presented in scenario C during the meeting on July 25th.
I think period there. Yeah, that's.
And that's good.
Mm-hmm.
There we go.
I think Patience just accepted the friendly amendment with a thumbs up.
Yeah.
Second, perhaps?
Second.
Mr. Stalker. Crystal, can I have you take roll?
Yes. Gonzalez?
Yes, and abstain as to Legal Access Alameda Legal Assistance for Seniors and the Family Violence Law Center.
Okay, thank you. King?
Yes, and abstain as to San Luis Obispo Legal Assistance Foundation.
Klein? Milrod?
Yes, abstain as to Central California Legal Services.
Pryor?
Yes.
Stalker?
Yes.
Falcon?
Yes, and I know there's a handful that I have to abstain to, but I don't know the names of all of them offhand. But the ones who do work in Riverside, I talked when we did the scoring, I highlighted them, but I don't remember which ones they are.
Thank you. All right, that's 6 yeses, 0 no's, 4 abstentions. So did motion passes.
Thank you, and thank you to Chris, despite not having received the baton for responsibility for committee yet, still helping out anyway. Thanks.
Excuse me, Jason, you said in answer to Bob's question, I think, there's some list that you can provide the bar of the organizations that you would abstain to, and that way we don't have to do it every time when we vote?
We still have to do it every time by our general counsel, but you could still preventively give that to us, and then when we do our sweep, if you miss something, then we'll go back and we'll fix it. But Brady wants you all to actually say it out loud.
Okay, all right.
It's not that convenient. It's more of a like just a safety precautionary measure, like in case you forget, as
exactly.
You know, Bob highlighted he had done. It's like, and I try to catch them all. Like, oh, the ones who do Riverside. When I'm reviewing them one by one, I mark it. It's harder when there's dozens of grantees all together to name them all.
No, what we do is sweep in. We'll catch it.
Right, so is that it for 4.2, and now we go to 4.3. which is 2024 IOLTA budget modification requests. Erica?
Yeah, thank you for having me back to talk about the IOLTA budget modification request. So as you all know, during the spending period for a grant, sometimes grantees have changes to their operations or to their programming and need to modify the budgets that they had previously approved by the commission. And so our office reaches out and asks grantees to submit those for ILTIF on at least a quarterly basis, as soon as they know that they require this budget revision. So for the second quarter, we received 5 budget modification requests. Only one of them rose to the level of needing committee attention. So pursuant to the functional matrix, any budget request that exceeds 25% of the grant award requires the committee to take a vote. Staff was able to approve the 4 other requests because they were below 25% of the grant award. And so the one request that needs your attention today was for 2024 IOLTA Award for Affordable Housing Advocates. And I just want to note the reason we have a 2024 award needing a budget modification is because the commission previously approved a 4-year spending period for this grant. And so many grantees are still spending down their awards from 2024. With Affordable Housing Advocates, their total grant award was $23,410. So a small award, and they had a deviation amount of $6,205, which brought them to 26.51% deviation. The explanation they gave us was that they had hired one individual, a bilingual legal assistant, at 0.6 full-time equivalent. That person didn't work the hours that they had previously agreed to, and they had to assign some of their funding that was originally for that position to one of their staff attorneys who was working on the same tenants' right project. And so she increased her hours to meet the needs of their clients. And so given that this is really just a shift from one personnel line to another, and it allowed the organization to continue providing the services that it intended to under the grant, staff felt that this was a reasonable justification and is recommending your approval of their budget modification. And I don't know if there are any questions on that, but if not, the proposed resolution is that should the GES committee concur, it is resolved that the Legal Services Trust Fund Commission Grant Eligibility and Support Committee approves Affordable Housing Advocates 2024 IOLTA budget modification request as described in staff's memo dated July 25th, 2025.
I'll move.
I'll second.
Great. Crystal, can you take roll, please?
Apologies, I missed who moved. Was that page?
King moved and Gonzalez second.
Wonderful, thank you. All right, I'll go take roll call vote now. Gonzalez?
Yes.
King?
Yes.
Klein? Milrod?
Yes.
Pryor?
Yes.
Stalker?
Yes.
Malkin?
Yes.
That's 6 yeses, 0 nos, motion passes.
Hooray. Moving on to 4.4, approval of late homelessness prevention 3 grant budget deviations. And I see Kim has joined us to present on that item.
Yes, hello everyone. Good afternoon. Kim Turner, Senior Program Analyst and Grant Lead for the Homelessness Prevention Work and Funds. Hopefully everyone can hear me. My internet is cooperating. Great. For now. So regarding 4.4, which is indeed the approval of late homelessness prevention 3 grant budget deviations, somewhat similar to Erica's item. We talked about, the functional matrix and things like that, but I'll go through it all in summary, very briefly. So as noted in the memo circulated to the committee, during the 2021, 2022 to 2024 Homelessness Prevention HP3 grant closeout process, the State Bar staff discovered 3 grants out of the 98 total awards that exceeded allowable budget deviations that required action. And so just to summarize quickly from the memo, the deviation details, there were 3 grants included in the memo, with 1 deviation between 10 and 25% of the total award. And normally that would be approvable by staff, but was elevated here due to the late timing. And 2 deviations are greater than 25%, which requires committee approval. The causes for these deviations range from grantee oversight to organizational changes and some reporting confusion, despite a lot of great staff technical assistance. So regarding the 3 grantee explanations, which are contained in the memo, we talked a little bit about grantee oversight, unforeseeable shifts, like, for example, one staff member being replaced by another due to a change in the organization's work and staffing, and slight, again, confusion about reporting processes, but we did do a lot of technical assistance. And the most important thing is to make sure that these deviations don't repeat. So we were very confident that all 3 grantees understood the issues and would not make those mistakes again. And we always are also looking at our processes to make sure they're very clear and transparent and accessible so grantees can easily follow those procedures. These 3 grantees are Affordable Housing Advocates, National Center for Youth Law, and USD School of Law Legal Clinics. So today, the State Bar staff recommends that the Grants Eligibility and Support Committee approve all of the 3 late budget deviations, particularly in light of the grantees having detailed corrective actions to prevent future similar deviations. Are there any questions or comments, knowing this is a packed agenda and there are a few more things? Okay, thank you. So I have the resolution on my screen. I don't think I need to show it, but I can read it if that works for everyone. Okay, so the resolution is as follows. Let's see, I'm sorry, I'm just going to pull up one other thing here. All right, so resolution, should the GES committee concur, it is resolved that the Legal Services Trust Fund Commission Grant Eligibility and Support Committee approves the 2021, 2022 to 2024 Homelessness Prevention HP3 grant budget deviations as described in staff's memo dated July 25th, 2025.
So moved.
Second.
Crystal, would you like to take a roll, please?
Gonzalez,
Yes.
King,
Yes.
Klein, Milrod,
Yes.
Pryor,
Yes.
Walker,
Yes.
Falcon.
Yes.
That's 6 yeses, 0 nos, motion passes.
Thank you, everyone. I appreciate your time.
Thanks, Kim. All right, that brings us to 4.5, partnership grant budget deviations. While we are on the topic of budget deviations, we will go to Mikey for picking up that.
Good afternoon. Thank you again. I'm presenting on 4.5, which is approval of late 2024 partnership grant budget deviations. So really quick overview. This is very similar to the last 2. Matrix allows staff to do approve deviations up to 10%. Anything above 25 goes to committee. So for the 2024 partnership grant awards, we had 37 awards, 3 of which had deviations, which are Legal Aid Society of San Bernardino, had the most significant deviation of 25.05%, or $41,339 of their $165,000 award. They shifted. The reason for the deviation is because they shifted from an attorney-focused service to paralegal support and virtual consultations. They also explained that their external accountant failed to flag the variance, which the organization understands the no oversight and has since then created stopgaps to ensure that that doesn't occur again. The next organization or grantee was Legal Aid Society of San Diego. They deviated on their $190,000 award by $23,358 or 12.9%, which is attributed to higher health coverage costs and increased office supply consumption from their satellite location. They miscalculated the deviations because they use a net subtotal rather than an individual line item, and only counted deviations of negative balances, leading them to believe that they were under the 10% threshold. They are now aware of how we calculate and will continue to calculate as the state bar does. And the last one is California Rural Legal Assistance. They had an 11.66 deviation of their $132,000 award, which equates to about $15,396. This was due to greater anticipation for demand for self-represented tenants requiring assistance with complex motions like demurrers. They attribute the deviation due to misunderstanding the methodology used to calculate the deviations, and they believe that they were under the 10%. They have since then updated their calculations to match state bar's calculations. Again, all three have corrected issues and have implemented actions or processes to prevent those in the future. So any questions before we get to the resolution? No? Cool. So should the GES committee concur, it is resolved that the Legal Services Trust Fund Commission Grant Eligibility and Support Committee approve the late 2024 partnership grant budget deviations for Legal Aid Society of San Bernardino, Legal Aid Society of San Diego, and California Rural Legal Assistance, Inc., as described in staff's memo dated July 25th, 2025.
Moved.
Second.
Crystal, can you go ahead and take roll, please?
Yes, Gonzalez,
Yes.
King,
Yes.
Klein, Milrod,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Falcon,
Yes, abstain as to Legal Aid Society of San Bernardino.
thank you. That's 6 yeses, 0 nos, motion passes.
Thank you.
Thank you. And with that, that is the last action item we have for the day. So I want to express my sincere appreciation for all of you. This was a longer meeting and quite a meaty action item at the beginning. So thank you all for your patience and participation. I hope you have a lovely weekend coming up. And with that, we'll call the meeting adjourned. Thank you.
Thank you.
Thanks.